Applicable law is one of the most critical, yet often overlooked aspects of contract formation. When disputes arise between parties from different jurisdictions, determining which laws apply can dramatically impact the outcome of your case. Applicable law refers to the legal rules and principles that a court or arbitral tribunal will apply to resolve a contract dispute. This concept falls under what legal professionals call conflict of laws, the process of determining which jurisdiction's laws should govern when multiple legal systems could potentially apply. The simplest way to establish applicable law is through a choice of law clause in your contract. Courts typically honor these provisions, giving parties the freedom to select which laws will govern their agreement. However, courts may disregard these clauses if they conflict with public policy or if the chosen law has no rational connection to the contract. What happens when a contract lacks a choice of law provision? Courts must then determine which jurisdiction's laws to apply. Most modern courts use what's called the significant relationship test. This approach examines which jurisdiction has the most substantial connection to both the transaction and the parties involved. Under this test, courts consider several factors: where the contract was formed, where negotiations took place, where performance occurs, the location of the subject matter, where the parties are based, and where their relationship is centered. The jurisdiction with the strongest connections will typically provide the governing law. Before applying conflict of law principles, courts first determine if a true conflict exists. A false conflict occurs when the laws of different jurisdictions would lead to the same outcome. In such cases, courts simply apply local law since the result would be identical regardless of which law is chosen. Cross-border transactions present additional complexity. Parties can designate national laws, state laws, or even non-state legal frameworks to govern their agreements. These might include transnational principles like the UNIDROIT principles of international commercial contracts, or the principles of European contract law. These non-state frameworks can be particularly useful in international commerce, offering neutral ground when parties come from different legal traditions. Arbitration tribunals are especially receptive to applying these transnational norms when appropriate. The applicable law is generally fixed at the time a contract is signed. However, new legislation may sometimes apply to ongoing contracts if transitional legal provisions explicitly state the law applies immediately to existing agreements. Two advanced principles further complicate applicable law determinations. Renvoi occurs when the law of one jurisdiction refers back to another legal system. Meanwhile, dépassage allows different aspects of a single contract to be governed by different legal systems. For example, performance terms might follow German law, while dispute resolution follows New York law. Courts also distinguish between substantive and procedural law. Substantive law governs the rights and duties of the parties, while procedural law dictates how cases are conducted in court. Generally, a foreign court applies its own procedural rules even when using foreign substantive law. Mandatory rules and public policy exceptions create additional limitations. Even when parties select a governing law, courts may refuse to apply provisions that contradict fundamental public interests or values of the forum state. This includes areas like competition law, labor protections, or anti-discrimination principles. Understanding applicable law is essential for effective contract drafting and dispute resolution. By carefully considering which laws will govern your agreement, you can provide certainty and predictability in your business relationships, potentially avoiding costly legal battles over jurisdiction and applicable rules.